welcome to Legally Speaking with me, Tarun Nangia. The Supreme Court has given a very landmark judgment in the case of Mihir Shah versus State of Maharashtra, where it says that written grounds of arrest have to be provided before a person is arrested, and it should be done well in advance. This will go a long way in sort of abating some concerns regarding arbitrary arrests when questioning would have been okay. But what is the real implication of this judgment delivered by Justice Bhushan Gawai and Justice Augustine George Massey? We will get to know from our eminent panelists. I want to welcome Justice Ajay Rastogi. Good to see you, sir. And sir has served as a judge of the Supreme Court of India until recently, and he's vocal on many issues pertaining to various judgments, and we look forward to his insights today. I have with me from Mumbai senior advocate Amit Desai, one of India's top criminal lawyers, who you see enough in Supreme Court as well as the Bombay High Court, and he will bring his view on the subject. I have with me senior advocate Atmaram Nadkarni, a well-known face in the national capital. He also served as the additional Solicitor General for India. Now he argues on a day-to-day basis at the Supreme Court of India. Good to see you, sir. I have with me Advocate Vivek Jain, who practices at the Supreme Court of India, the Delhi High Court, and also other high courts across the country. Good to see you, Vivek, and thank you for your time. At the outset, may I request uh, Justice Ajay Rastogi to make the opening comment before we move on over to you, sir.
So nice, Tarun, giving us opportunity to address and to express our views. And this is really a burning subject going on. And there was an arbitrary arrest you will find every day in the morning when you read the newspapers, and people are making their comments. I'm not going into the merits of the nature of comments, but I just introspected myself after the judgment came. That persuaded me to look into that Article 22 of the Constitution. If you see Section 50 or 50A of the old CRPC, which is a reproduction of 47, 48 of the new BNSS. The question is, the provision is self-explicit and clear in terms. It leads no manner of interpretation, no ambiguity, no further discussion on the subject. But the previous judgments on the question always came when there was a special acts. Either it is a PMLA or a UAPA or other special acts where the arrests have taken place. Now, my only worry is one thing. I respect and agree with the view expressed by the Supreme Court, but the consequences which have been said of non-supply before 2 hours of the production will make the arrest non-est and he has to be released. That is my worry. You see, consequence, I feel, subject to what the other panelists want to express, should have been left for the court to examine. Because if you see the preventive detention under Article 22, Clause 5, you arrest the person, 3 months is there, detention, reasons are assigned, committee is constituted, committee will examine and take a course. Now, this judgment will take care of in all matters. Either it is a preventive detention or arrest. So, my view is consequences of the non-supply or the reasons would have been left for the court to take a call rather than taking a call straight away, blindly, that he should be released forthwith if consequences are not there. And only one worry more. Suppose the reasons assigned by the time man is taken to custody or 2 hours before the production are 2. But the court finds that no, these may not be sufficient. There are other reasons for arrest which may not have been disclosed. Meaning thereby you have to release him, and the consequence say thereafter again supply the reasons and arrest him. It is practically impossible. It is impractical and impossible. So my request is consequences has to be reconsidered, and to my view, leave it to the court to take a call as to what will be the consequence if non-supply of the reasons before 2 hours or production before the magistrate's court.
Thank you, Justice Rastogi. That's why I like your interventions. You speak your mind on various issues. and bring some insight with your own experience. Thank you so much for your opening comment. We go to Senior Advocate Amit Desai, who joins us from Mumbai. So we see you arguing on some of the top promoters of the country when they are incarcerated, some top politicians also in the past few years, Bollywood actors, and the question of liberty you have espoused in all these issues. Given that as the background, how would you take this judgment by Justice Bhushan Gavai and Justice Augustine George Massey?
Tarun, firstly, thanks. You've been carrying on this program of yours to educate, I think, the citizens of this country about all the burning issues which affect them and their legal rights. And I think it's important to continue to do what you're doing. And in this context, let me tell you that the question of liberty, of course, has been something that the Supreme Court has been struggling with over the last several decades, but more so as we saw in the last 6 or 7 years. And in the last couple of years, what I have seen, and I would call this particular decision a landmark and a part of what I call the threshold of judgments of the Supreme Court on the question of communication of the grounds of arrest. This entire issue arose in Pavan Bansal's case, where really, this is something which, as a practitioner in this field for all these years, the constitution was fairly clear. The provisions of the CRPC were also fairly clear. But one could see what was happening on the ground and how liberty was actually being impacted of many citizens. And therefore, in many ways, Pavan Bansal came to the rescue at step one to bring in some kind of checks and balances in the exercise of the power of arrest. And that's where they first time clarified what was probably implicit in all these provisions is a question of communication and communication in writing. Uh, the second is Vihan Kumar, which then set out the consequence issue that because if there's a violation of a fundamental right, which is under Article 22, then what is the consequence of a violation of a fundamental right? And it is important that the agencies of this country must recognize what the fundamental rights of citizens are. And then, of course, is this third judgment, which makes this position very clear and extends it to all legislations where there's an exercise of the power of arrest. Having said that, this is something that is necessary because when you see what's happening across the length and breadth of the country, different police officers tend to interpret the problems differently when they exercise the power of arrest. And these judgments now make it mandatory for police officers and all investigating agencies in all types of offenses to follow a particular process, namely to communicate in writing and, more importantly, in the language that the accused understands, the grounds of arrest. That is also a very important. Now, what it also explains the rationale, it says that when you're taking away somebody's personal liberty, you need to give the grounds of arrest to enable them to have access to a lawyer who can guide them on how to deal with the question of their personal liberty. So that therefore, when they go to court, the lawyer has the ability to actually argue on the questions of personal liberty, the reason for arrest, the reason for continued custody, etc. So that is where also this particular judgment, in my humble opinion, actually clarifies matters so that agencies can be, don't have to take different views. And that is what was being commented upon even in the past by the Supreme Court in various of the judgments. Only interesting angle which they then additionally brought out was the question that came up directly in the context of that matter. And they then said that in exceptional circumstances, you may not give the grounds of arrest at the time or prior to the arrest. You may even give it subsequent to the arrest, but they put in the caveat of 2 hours prior to being produced in remand. The interesting thing that they've drawn, and I think they've tried to probably draw a distinction between the situation where grounds of arrest are not furnished in normal circumstances, where they said the consequences that the arrest is illegal, and the exceptional cases where you may not actually provide for the grounds of arrest at the time of arrest, but you must give it 2 hours before. Then in that situation, they then put in a caveat to say that it is left to the court to determine whether there is an illegality in the arrest in relation to that second situation, which is a situation of exceptional circumstances. So I think the court tried to balance the situation because very often we had a very interesting case in Bombay where an accused who was standing in a police station suddenly picked up the revolver of the police officer and shot a few people in the police station. Now, this is obviously a crime in the face of the police officer. An instant FIR was registered. The question comes up: do you need to then actually give grounds of arrest for a situation like that? Obviously, you don't give grounds of arrest. But the Supreme Court has tried to bring in 2 hours, because if there is a question of a grave and sudden provocation or something of that kind, which is not apparent, then you have the ability to have a lawyer defend that particular accused. But there are these exceptional situations which do arise, where it may not be necessary or possible to give such grounds of arrest immediately. So I think this balancing has been done, but I think the important thing is that it has clarified the position so far as all police officers and investigating agencies are concerned, that this is the mandate of the law and it must be followed. And I say that, why is it that consequence must be the consequence of the declaring the arrest illegal? It's important that these agencies must now understand the Constitution, and they must face the consequences for not complying with the constitutional obligations. And one consequence is, of course, the release, because then there'll be disciplinary action, I assume, against the officers internally as to why did they not comply with the constitutional obligation. And slowly, the agencies will start realizing that they must comply. So whilst one doesn't want criminals to run scot-free, and no doubt about it, they need to be dealt with in accordance with law, and that's why the 21 principle is also touched upon by the Supreme Court. It's important that even the agencies recognize the need to comply with constitutional obligations. So these are my preliminary sort of thoughts on this particular judgment.
Thank you for expressing so lucidly about also the issue of upholding of constitutional rights and duties with regards to liberty. Now we have Senior Advocate Atmaram Nadkarni. If you remember, sir, you argued very vociferously that even government officials should not be summoned unnecessarily by courts. When we did a recent show with you and Mr. Mahesh Agarwal, you said, and you have been sort of a libertarian in that sense. So, given your thoughts that we know, what would you make of this landmark judgment by Justice Bhushan Gawai and Justice Augustine George Masih?
Yeah. This undoubtedly is a landmark judgment for more than one reason. Tarun, the first thing is Article 21 is very sacrosanct. 22, 23, these are all parts of it. But when it comes to personal liberty, there can't be any compromise. At the same time, if a person is accused of a criminal offense, then he must be brought to the rigors of law and he must be punished. There is no doubt about it. Just because you have a personal liberty, that doesn't mean that you can go on doing offenses and in the guise of public personal liberty, you will not be prosecuted and punished. Our Supreme Court, taking note of the fact that Article 22 has been effectuated by the legislature earlier in Section 50 of the Criminal Procedure Code, later now in the Bharatiya Nyaya Sanhita case, BNSS, there were 3 judgments of the Supreme Court, as mentioned by Mr. Amit Desai, my friend, Pankaj Bansal, then there is Prabir Puryakasta, and there is Vihan Kumar. Irony is, despite these 3 judgments of the Supreme Court mandating that the grounds of arrest must be given, the grounds of arrest were never supplied by the police or many other authorities, even under PMLA, etc. People were arrested. Invariably, you will find in the bail application that the grounds are taken, that the grounds of arrest have not been furnished. And in the counter, the state either doesn't deal with it or deals with it very casually. So the first important facet of the judgment is it has considered all those 3 judgments and laid down that what has been laid down earlier is a mandatory condition. Before you arrest, you must furnish the grounds of arrest. So that's one thing. The second thing, as has already been pointed out by Justice Rastogi and Mr. Amit Desai, is about the exceptions which are carved out. And as rightly pointed out, there could be situations where, accused who is absconding, you see him somewhere. Now, you can't, go on writing the grounds of arrest, give it to him in writing and all that. You have to catch those kind of accused. Similarly, the other incident about shooting in the police station, or a fight which takes place and you want to do. So all those different kind of exceptions are there. Now, I also tend to agree with what Justice Rastogi said at the beginning, that giving consequences, namely that the arrest would be illegal, is a little something which the Supreme Court should have considered. But rethinking on the matter is that court always has a discretion. Thereafter, the superior courts, of course, the Supreme Court, High Court, they always have a discretion. But once something is mandatory, then the consequences ought to follow and must follow. And despite Supreme Court saying that it is mandatory in the earlier three judgments, laying down the law, the police have not been following it. And it's most unfortunate that the courts have not been taking it very seriously either. They just go on the merits of the matter and they will decide on the merits. There are cases, judgments which have granted bail because it is you have violated the liberty and violated Article 22 thereby. But this judgment, in a way, is a landmark judgment, and I'm glad the way the judgment has been worded. They've carved out different situations. Even in the conclusions, different paragraphs give different facets of that variant matter. And there is no doubt that this is a vexed question and it raises different variants at different point of time. And it is something which has to be dealt with subject wise. So
Thank
those are my opening remarks.
thank you, Senior Advocate Atmaram Nadkarni, for your opening comments. We'll go to Advocate Vivek Jain for his opening comment.
Well, thank you, Tarun, for inviting me here. Well, there's a saying, Tarun, that hard cases a lot of times make bad law. Now, I would say if you see the facts of this case, this is a case which had hard facts. Here is a person who is taking refuge in grounds of arrest non-compliance, who has actually dragged his victim in a hit and run case, and both of them have suffered a fatal injury. Now, it is very easy for judges to actually go by the moment's compassion, full of sympathy, and distort the enduring principles of law. Now, this has not been done in this case. Though that grounds of arrest non-compliance was the ground taken by the accused, the judges have actually stood with the enduring principle which Supreme Court has formulated on Article 21. Now, what are those enduring principles? As my learned colleagues, my learned panels have already said, the first judgment was Pankaj Bansal, which is in the context of PMLA, where they said that you have to give it in writing. A person who is arrested would not be assumed to be in a state of mind where he could actually, see and remember all the grounds of arrest if you just tell him orally. That was a basic concept on which Pankaj Bansal was delivered. Now then comes Praveer, where Praveer actually extends this to UAPA and say that if it's a principle under Article 21, then you can't distinguish between the statutes. You can't distinguish between UAPA or PMLA. If you're applying in one statute, you have to apply in other also. Now, the third judgment, which I think was referred to as Trishul by just by Mr. Desai, was Vihan's judgment, which actually applies for the first time this grounds of arrest compliance to the normal law, to the CRPC law, section 50. Now, still there was a vacuum, and I think how and why were already there. How and why we know the jurisprudence under Article 21. When was in fact the question which was troubling the court? Because the question asked in this case was whether when he was arrested or accused was arrested, the grounds of arrest should have been given. Now, while dealing with those factual circumstances, the court endured with the principles of Article 21 and said that there might be some circumstances, like there might be a hard pursuit, or like an example given by Mr. Desai, you won't be able to give grounds of arrest. But still, the court has, in fact, by a judicial decision, has in fact enacted some kind of a principle where it says that 2 hours before his remand, you give the grounds of arrest. If you can't give it, during the arrest, you give it before the remand so that he can adequately protect his rights and he could inform the lawyers. Now, this is very important, and this actually sets the tone for the procedure for whole of the country, because right now, till now, there was a confusion as to what should I do? Should I just have a written grounds of arrest in my pocket while arresting a person on a hot pursuit? You can't. Now, this is the situation which actually got resolved by this judgment, where in fact a clarity is given to the police officers also that no, you are not required to give it just then. But still, the caution and the principles of Article 21 was retained to say that you have to give it before the remand application. According to me, that are my opening comments, and according to me, it's a landmark judgment as been told by my distinguished panelists.
Thank you. But how long before the remand application is uh, what is to be left to the agency, or there should be that also should be mandated? Maybe you can answer that later. I'll go to senior advocate Amit Desai. Mr. Desai, be it film star Salman Khan or the Ambanis or Adanis, you have represented top promoters, Bollywood actors, many times also many promoters in liberty cases. Would you agree with me when I say that many promoters are hesitant to go for questioning as they fear that they may be arrested on the pretext of being called for questioning? Is that fear does that fear make them evasive? Evasive as in they fear to go and attend, in a sense, the questioning. Could you sort of decode this for us? Because from how lawyers think, businessmen think differently. Maybe many of them face cases for the first time in their life, and there is a great degree of fear in, however, whatever response they give to a situation. Could you share your insights with us?
So, Tarun, I'll not limit this to any big businessman. This applies to every citizen. I'll tell you that. That whenever there is a criminal investigation and a summons is issued, there is always a sense of fear. Depending on the role of each individual, depending on the person involved, whether he's a habitual criminal, whether he's really committed offense, all kinds of people. But when you talk about a certain segment of the people, namely the business community, I think who watch your show probably a little bit more than probably the others who watch your show, and therefore this might be more relevant to them. I think it's not just the big bosses who sit there. Everybody in that organization will be concerned and nervous about going. And I think the question that really arises is this, that at least in relation to the offenses that are punishable with up to 7 years, the principle has been now established by the Supreme Court on a construct of the old Section 41A of the Criminal Procedure Code, which was an amendment that was introduced and sometime in the early 2000, and that now has been reintroduced again in the context of Section 35, subclause 3 of the BNSS. Now, the principle behind this, in my view, was that it actually, for offenses which are punishable up to 7 years, it was a legislative mandate that the ordinary rule which police officers and investigating agencies actually have believed that they have a right to arrest, whenever they feel like it, and that's what was really happening. There was a legislative interact to say that ordinarily for offenses which are punishable up to 7 years, you will not effect an arrest so long as you are willing to cooperate with the investigation. This is something that has been actually going on. It was there articulated in some ways for the first time in the mid-90s in Joginder Kumar's case. It was drawn from principles from a Canadian Supreme Court decision, which was referred to in Joginder. That principle, again, the police officers and agencies never followed it, and therefore, ultimately, the Parliament brought in 41A to try and actually restrict the power of arrest. This has come back into 35(3). Now, what happens is that since this 41A, again, is a provision which is always observed in many ways in the breach, because as we know that 41A got interpreted for the first time in Nanesh and then got reaffirmed in Until's judgment. It essentially laid down the obligation of a magistrate who before whom an accused is produced for remand to satisfy himself that all constitutional and statutory obligations are first complied with before he can consider the question of remand. They elevated 41A to such an important right to say that if there's a violation of 41A, then ordinarily the magistrate should not grant a remand. And yet, and in Anesh, and again reaffirmed in Until, the consequences, and I'm mentioning consequences because we are debating the question of consequences on your show in relation to Article 22, etc. The consequences of non-compliance of 14(1)(a) were set out in both those judgments, and there were very, very serious consequences that the Supreme Court set out in those judgments. One of the consequences was contempt, and the second was even disciplinary action so far as the judicial officer is concerned. It never happened, but these are the consequences that the Supreme Court set out, because that was the importance of interpreting this section and providing for protecting personal liberty. So Supreme Court has, in the context of personal liberty, dealt with the question of consequences in different forms whenever there's a violation, when it deals with personal liberty. It's important that the agencies recognize this and do not allow the criminal to escape. And the problem is that very often where there is a real criminal, they often also always escape. And those who are probably on the borderline tend to suffer. The innocent suffer more than the guilty, which is the problem. And I understand that when a court is assessing the problem and trying to manage it, dealing with it, they must necessarily deal with the problem that when there is a guilty, he should not be allowed to escape the rigors of the law only because some innocents may suffer. I understand that's the way the courts look at it, because look at the kind of crimes that are happening today in this country. They're very serious crimes, and people take advantage of these kind of technicalities and loopholes. There's no debate about that in my mind. But how do you change the mindset of these agencies? And unless the court starts coming down and providing for very serious consequences on the people who actually breach these statutory provisions, is never going to change. So when you come back to the question about fear, undoubtedly there is fear, because what happens is that even though the Supreme Court lays down the law, when it comes to actually investigating a matter, do they follow these principles? If they followed these principles, I think things would have been much easier and there would have been less of these problems. But this is the challenge that we face today. And I'll just add one more thing with the context of the question that Atmaram also raised earlier, and that is about this question about counsel. And I want to bring out that element. If you see 22, and 22 not only talks about communicating the ground, but also a right to consult lawyer. Now, when you marry the two, how do you actually get to that point unless you actually then say that if a person is going to be produced for a remand, then if you have the right to consult, it must be an effective consultation. That effective consultation must be to give him some material, which is the grounds of arrest. When do you give it? Now, the Supreme Court felt that 2 hours is a reasonable time so that he can effectively get representation and seek legal advice, which is also part of Article 22(1). So I think that's where I see that the Supreme Court tried to bring in some kind of balance in the context of the constitutional rights of consultation, especially in the context of liberty matters. So that's the other angle that I thought I should just put on the table for debate. Thank you.
Thank you. Thank you for explaining this so lucidly. We'll go to Senior Advocate Atmaram Nadkarni. Now, you recently appeared in a Zenito Cardozo case in Supreme Court with Senior Advocate Mukul Rohatgi, where also the question of liberty was involved. It was a very high-profile case. Of course, you got relief there. Be it a criminal, high-profile, a politician, or a businessman, do you see that because there is a sort of a disbelief that you may be called for questioning and on that pretext arrested, also leads to a lot of evasion? What I asked Senior Advocate Amit Desai, could you sort of clear the air on this?
Yeah. Tarun, this is a very relevant question. Since last several decades, very unfortunate that the law enforcement agencies in these countries are ridden with complete corruption. In fact, I'll give you an example, and one of our panelists is a witness to what I'm telling you now. There is a site called as shadi.com.
Yes.
Two people in Hyderabad got through on the shadi.com, they got connected. And before it could materialize into Shadi, there was some loan taken from one by the other and all that. And that loan was never returned, and Shadi also never took place. Shadi.com had only facilitated of bringing these two people together. Hyderabad police registered an offense. The lady, when she filed against that boy, never even mentioned anything about Shadi.com, but only mentioned that we were brought about by this Shadi.com on this website. The Hyderabad police sent a summons to the managing director of the Shadi.com. And when that summons, in response to that summons, when that person from Shadi.com appeared, he was arrested. In such circumstances, anticipatory bail was moved for before the High Court. The High Court rejected it. And finally
Yeah.
rejected. We came by way of SLP during vacation. And in the vacation, the bench protected us and issued notice and went to the extent of saying that what is this happening in the country? In fact, I was briefed in that matter by Mr. Vivek Jain, one of our esteemed panelists. It was his matter where we appeared in the Supreme Court. So, what I'm telling you is that the tendency to arrest is not only for investigating an offense, it's because of this things which are happening that we are required, to be very careful. And with that experience, these judgments of Pankaj Bansal and all other judgments, which even Mr. Amit Desai mentioned just now about arrest, etc., came to be delivered. So it's very important that the Supreme Court and the constitutional courts are alive to this fact that arrest of a person creates so many. This judgment, in fact, has taken a note of it, that the arrest of a person has severe consequences. Some people may be driven to even commit suicide because he might have an unblemished reputation. And suppose at a late age and for the first time in life, that too for not having committed an offense, if you are arrested. So, therefore, this police, they don't even think, these agencies look at the way PMLA arrests have been done. It's a law which deals with the proceeds of crime. The proceeds of crime are roaming all over the world, and you are just putting that accused behind bars, and from the jail, he is laundering the proceeds of crime. So that's very unfortunate. So the answer to your question was that this constitutional courts have done it because, and the apprehension of every person summoned that is going to be arrested is not something which is ill founded. It is not baseless. There is a genuine apprehension that the police will misuse the power and arrest the person.
You have sparked a larger debate, Senior Advocate Nadkarni. I'll tell you why. A promoter, if this happens to him, may take citizenship of another country, and investments in India genuinely get affected
Correct?
when other investors abroad hear these stories. So a lot of job creation stops. We sort of don't look at this unintended impact, that somebody intending to maybe invest 2,000 crores will not put that money because he fears that some random case and he himself will be sort of behind bars. But thanks for sharing this anecdote with us. We'll go to Advocate Vivek Jain for his insights. Also,
Well, Tarun, there are a few points I actually wanted to tell. One is, of course, the one you asked about 2 hours. So now I think Supreme Court has lucidly held that 2 hours prior to the remand application, you have to give arrest in exceptional circumstances. So in the normal course, you have to give the grounds of arrest at the time of arrest. And the apprehension which you had suggested that, sometimes people are called during investigation, and when they were called, they were taken, they are arrested. Now, for that, in fact, this judgment actually deals with the situation. And in fact, in one of those paras, I think para 51, it actually says that if you are calling a person under 41A, which means that you already have documents, this is a documentary case, a nature of a document. And so if you already have documents and information, then you have to give grounds of arrest at the time of arrest. I think that much the court has clarified in
at the
this at the time of arrest. On arrest. In fact, it says on arrest has to be furnished to the arrestee on arrest. Now, there is one more interesting uh, topic. Mr. Desai actually touched upon it. There is a judgment of Vihan, And in that, Justice Oka has written the main judgment. But there is a two paragraphs of concurring judgment of Justice Koteshwar Singh. Now that is also very relevant because in that small two paragraphs of judgment, Justice Koteshwar Singh had said that in view of the principles of 50A CRPC, not only you have to give grounds of arrest to the arrestee, it is incumbent upon you to give grounds of arrest to the relatives of the arrestee. So the whole idea was to prepare the accused in case of his arrest or his relatives or his family members to engage somebody and to know as to why somebody is arrested. So I think the law, how it is progressing, it has actually protected Article 21 rights of an accused, but it has also led to a very serious thing that constitutional safeguards, you can't leave it at the doors of police station. You can't leave it because that's what our example was, and therefore therefore the courts have to be activists. They have to make do with whatever they have. And you see the kind of activism you've seen in this judgment, where you actually got a rationale of 2 hours. 2 hours, 2 hours guidance is nowhere provided in any of the act or any of the statute or CRPC, BNS, BNSS. But they have to do it because that's the need of the hour. And also, if you see the democracy, so when you in fact there's a quote that you can't measure a democracy with the kind of statutes or law which you enact. It is also about how jealously you protect the right of individual after the statutes are provided that right. So I think the courts have done a very fantabulous job and an amazing job, and this is a landmark judgment to that extent, that it has protected, and in fact procedurally it has laid foundation, and in fact it has clarified to the police officers that power of arrest, you might have power of arrest, but it cannot be equated with arrest. You have to be able to justify arrest. Now that is the most important principle which has been Supreme Court has been laying down in one judgment after another. But this judgment actually cements it, and obviously gets some kind of a authority over the police officers also, that see, here is a magistrate who is also being imposed with a duty to see if that you've arrested a person without the legal grounds or not. So I think now we are in a system and in kind of a legal system where the procedures have now been has been put in a straitjacket formula, and there is no confusion as far as the individual's rights are also concerned.
Thank you, but and we must thank the Supreme Court for reiterating the grounds of arrest issue, and I'm sure the Supreme Court will get it implemented also if there is now not it's not now followed like Senior Advocate Amit Desai highlighted along with Senior Advocate Atmaram Nadkarni. It's always said that the judge has the last word. All the three advocates have argued. We'll go to Justice Ajay Rastogi for the last word and his observations on what all the three panelists have said. You're not audible.
You see, personal liberty is sacrosanct, no doubt about it. Article 21 protects the rights of an individual. It has to be. But we have to see 22 and the relevant provisions in CRPC in coherence. Like Atmaram has said, if somebody commits a crime, Amit also said, he must know the consequence of the crime being committed. Now the question is how to book the man who has committed the crime and what procedure to be followed. Let us go to Article 22 in the first instance. Article 22, subclause 2 says within 24 hours you have to produce. Before whom? Before the magistrate. If somebody is arrested, within 24 hours you have to produce. Now, if somebody is produced within 24 hours, the person who is taking the detainee under custody for whatever the offense like he has committed, he has to produce those reasons for this purpose of remand. If you see section 47 of the new BNS Act, it also takes care of the same thing. Fourth will. I think if it is subclause 1, it is fourth will. Supply the warrant, supply the evidence or the document on the basis of which arrest is taking place in fourth will. Fourth will has been taken care of in a different way because of the practical difficulties. I fully agree with it. the man who is taken into custody must know the reasons of arrest. So otherwise, he's completely in dark. And particularly, this happens in the economic offences. Either you take PMLA, either you take the offence like UAPA, either you take GST, or other economic offences. The man is completely unaware of what kind of a reason forthwith coming forward with the agency of taking me into custody. He, as you said, he is called there for interrogation. And since he is not answering to your queries to the satisfaction as you desire, his man is put under arrest. That I fully agree, it's unfair. This kind of action of the police authority must be debated. Well, the law never contemplated it. Compliance has to be made. But when you see different nature of crimes going on around the city, where the two persons are fighting, the neighbors are fighting, or the political leaders are doing something wrong somewhere, consequence have to be kept in mind. Otherwise, what will happen, I tell you. And I will be wrong in my approach and I must prove to be wrong. If we will take consequences on its face value without determination being given to the authority as to what will be the consequence, when the consequence goes fatal, it will lay down a very bad precedent in cases to come. You see, you can't educate the people overnight. Now, if somebody commits a crime and he is not being able to provide 2 hours before he is being produced, he is supposed to be, because within 24 hours he has to be produced. And suppose I just put one instance. The offence is committed somewhere in, say, in Maharashtra. Arrest is taking place in Assam. He has to be produced before the magistrate's court in Assam within 24 hours. Now, they say give this either to the arrestee, the reasons, or to the his relative. Now see the consequence of it. Within 24 hours in Assam, man commits crime in Maharashtra, belongs to Bihar. How these three states where the things goes on have to be synchronized. How to synchronize. Now, if you say that since it has not been made available, the custody or the detention or the arrest goes illegal. Somewhere down the line, I think to be somewhere kind different. So it has to be synchronized. So what I said in the beginning, the consequence of non-compliance of the mandatory requirement of section 47 in the new act must be left for the court to determine as to non-consequence is fatal or not. Otherwise, what will happen? Immediately, if reasons are not forthcoming, or reasons are not properly supplied, or the reasons are the reasons supplied are 3, 2 are not available at that time, which they add later. Then the question will go to the Supreme Court. The reasons assigned for me for taking into custody was 1. The other reasons are not available. So this reason goes, release me just now. The fresh reason, fresh arrest. So I don't know how the things will work out. But I welcome the judgment. At least it will give an eye-opener to the university agencies to use their brain, find out the reasons before arrest. And you can't arrest someone randomly. Let us see and welcome that consequence will be better for the institution to fund. And when we say about 21, personal liberty, which is sacrosanct, let us see how the things roll further. Personal liberty on the one side, detention on the other side, custody on the other side. Let us see. I welcome the judgment. It will give an eye opener to the investigating agencies to find out how to take the step forward.
Thank you. Thank you so much for reflecting this opinion and praising the Supreme Court judgment delivered by Justice Bhushan Gavai and Justice Augustine George Massey. The promoter business community will be delighted with this judgment, given the fact that they all say that they fear that they will go up for questioning and may be arrested. We will do more shows on this topic. But today I would like to thank Justice Ajay Rastogi, served as Judge Supreme Court of India, now is a leading arbitrator. I have with me Senior Advocate Amit Desai, who joined us from the city of Mumbai, Senior Advocate Atmaram Nadkarni, and Advocate Vivek Jain. Thank you so much for your time because
Thank
liberty.
you. Thank you, Tarun.
Thank you.
Wonderful show yours is always is.
I always say Tarun is doing a wonderful job. and making everyone aware what is happening in the legal field.
Thank you. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.